Good day. So our lesson for today is Rule 122 on appeal. Who may appeal? Take note it's any party. Any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. So by this section, we can say that if it is for a judgment of conviction, usually the aggrieved party would be the accused. But it would not prevent the private offended party from appealing as well, considering that the rule says any party. Now, what about if it is acquittal? Remember in acquittal, when we had Rule 120, that judgment of acquittal is immediately final. In other words, the private offended party or the state for that matter cannot appeal an acquittal of the accused. To do so would place the accused on double jeopardy. You will learn later why he would be placed on double jeopardy. But if it would be the accused when he will be convicted and then he initiates an appeal, he will not be placed on double jeopardy because such action on the part of the accused shall be taken as a waiver on his part against double jeopardy. Okay, so there would be waiver of double jeopardy if initiated by accused. Why would that be? Because on appeal, you actually throw the whole case open for review by the appellate court. The appellate court can review errors whether or not assigned or unassigned by the appellant. By the way, the party who initiates the appeal is called the appellant. The other party is the appellee. As a rule, factual findings of the trial court, especially when affirmed by the CA, deserves great weight and respect. Why? Because the trial court is in a position to observe the demeanor of these witnesses when they actually testify in court. So that's the reason why factual findings are given great weight and respect by the appellate court or by the High Court, the Supreme Court, especially if the same was affirmed by the CA. Now, where do you appeal? From who? Where to appeal? The appeal may be taken as follows. If the trial court or if the court who conducts trial are the first level, either Metropolitan Trial Court or the first level courts found in NCR or Metro Manila, Municipal Trial Court in cities if the first level court is found in chartered cities outside Metro Manila or NCR, Municipal Trial Court if the first level court is located in a municipality, or Municipal Circuit Trial Court if the court has jurisdiction or covers more than one municipality. So that is a circuit. If these are the trial court or the court of origin, you appeal to the regional trial court, who has jurisdiction as well over the first level court who tried the case. Okay? RTC, we will still talk about jurisdiction. So the RTC who has jurisdiction over the first level or over the place to where the crime was committed. It follows, okay? It follows. Now, how about if the same was decided by the regional trial court? Where will you appeal? To the Court of Appeals or to the Supreme Court in proper cases? And to the Supreme Court in cases decided by the Court of Appeals. So from who, where, let's proceed to how. How to appeal. To appeal The appeal to the RTC or to the Court of Appeals in cases decided by the regional trial court in the exercise of its original jurisdiction, appeal shall be by filing a notice of appeal with the court which rendered the judgment or final order appealed from, and by serving a copy thereof upon the adverse party. Appeal to the RTC, yes, MTC to the RTC, original jurisdiction, notice of appeal. Now, if RTC to the Court of Appeals, in the exercise of its original jurisdiction, meaning to say the trial court is the RTC, appeal is by filing a notice of appeal. Now, notice of appeal, where will you file it? With the court which rendered the judgment or final order appealed from. In other words, if it is first level to the RTC, the notice of appeal shall be filed with the first level, the trial court. If it is RTC exercising original jurisdiction to the CA, notice of appeal shall be filed with the RTC, the trial court. Now, how about if it is appeal to the CA in cases decided by the RTC in the exercise of its appellate jurisdiction? Meaning to say, the court of origin is the first level. There is that appeal to the RTC. And despite the fact that there is already judgment of the RTC, the aggrieved party reach up to the CA. So that instance, the RTC there is actually exercising its appellate jurisdiction, not in the exercise of its original jurisdiction, because it was the first level who originally tried the case. The appeal shall not be by notice of appeal, but by petition for review under Rule 42. Rule 42, you will have the details on this when you will have your civil procedure, the same. Okay? The appeal to the Supreme Court in cases where the penalty imposed by the RTC is reclusion perpetua or life imprisonment, or where the lesser penalty is imposed but for offenses committed on the same occasion or which arose from the same occurrence that give rise to a more serious offense for which the penalty of death, reclusion perpetua, or life imprisonment is imposed, shall be by filing a notice of appeal in accordance with paragraph A of this section. Now, take note that while there is this provision of the law, RTC imposing reclusion perpetua, life imprisonment to the Supreme Court, we have this decided cases already which settled the principle that we have to observe the hierarchy of courts. What do we mean by this? That instead of appealing directly to the Supreme Court, you have to appeal. You have to pass through the Court of Appeals first in observance of the hierarchy of courts. In other words, you shall not go directly to the Supreme Court. You have to pass through the Court of Appeals. For that case that you seek to appeal imposed by the RTC that carries with it a penalty of reclusion perpetua or life imprisonment or even death. Following paragraph A. Now, no notice of appeal is necessary in cases where the death penalty is imposed by the RTC. Why? Because the same is considered or submitted under automatic review. Okay, automatic review. Except as provided in the last paragraph of Section 13, Rule 124, all other appeals to the Supreme Court shall be by petition for review on certiorari under Rule 45. So this notice of appeal, again, even if the rule says that in case death penalty is imposed by the RTC, automatic review by the Supreme Court, hence no notice of appeal is necessary, still in observance of the hierarchy of courts, the automatic review shall be done first by the CA. Okay, shall be done first by the CA. Okay, so if you notice, for those criminal cases where reclusion perpetua, life imprisonment, or death is imposed by the RTC, go first to the CA before the SC, before the Supreme Court. If it is reclusion perpetua, life imprisonment, notice of appeal to the CA. If it is death, automatic review to the CA first. Before everything shall go to the Supreme Court in observance with the hierarchy of courts. All the rest, for cases decided by the RTC and the aggrieved party reach up to the Supreme Court, if it reach the Supreme Court, the mode shall be by petition for review on certiorari under Rule 45. Rule 45, again, you will have this in your civil procedure. So, to outline as to how to appeal, you have here from MTC, MCTC, MTCC, or METC, first level. Where do you appeal? RTC. How do you appeal? Notice of appeal filed with the MTC. Okay? Notice of appeal filed with the MTC. If you want to appeal the decision of the first level, so MTC includes MCTC, MTCC, METC to the RTC by notice of appeal. From RTC to the CA, how do you appeal? If the order or decision that shall be subject for appeal is decided by the RTC in its original jurisdiction, notice of appeal filed with the RTC. But if the order is in the exercise or decision is in the exercise by the RTC of its affiliate jurisdiction, the appeal shall be by petition for review under Rule 42. Where do you appeal? CA. Okay? RTC to CA. Now, if penalty imposed is reclusion perpetua or life imprisonment, notice of appeal to the CA. However, again, we have to observe the hierarchy of courts. Meaning to say, notice of appeal to the CA first. But if the penalty imposed by the RTC is death, no need to file the notice of appeal because the same shall be done under automatic review, but still observing the hierarchy of court. So the same shall be done by the CA first prior to going to the SC. If the aggrieved party, despite the fact that the CA had acquired jurisdiction of the appeal, either through automatic review or petition for review, still aggrieved, reach up to the SC, the mode there shall be by petition for review on certiorari under Rule 45. This petition for review on certiorari is also known as appeal by certiorari. Do not confuse yourself on Rule 45 because Rule 42 says petition for review. Okay, so we're done with the RTC. So how about in Court of Appeals? Where do you appeal? When Court of Appeals impose a penalty of reclusion perpetua or life imprisonment, CA may file a notice of appeal as a matter of right, and the same shall open the entire case for review on any question, and it may include question of law or fact. So this involves cases where the question involves law and fact. But if the issue to which the appeal shall be done after the same has been decided by the CA is purely questions of law, then the mode shall be by petition for review on certiorari. Petition for review on certiorari. And that we consider it as a matter of discretion. When CA affirmed the death penalty, proceed to the SC under Rule 45. Petition for review on certiorari or appeal by certiorari. Now, how about in the SC? Of course, the SC there is your court of last resort. To whom will you appeal if you are still agree with the decision of the SC? To your God. We cannot do anything more because we consider the SC as the court of last resort. So, as a recap, where and how to appeal. MTC to RTC, notice of appeal. Where will you file the notice of appeal? MTC, Court of Origin. Again, MTC includes the MTCC, MATC, MCTC. Okay? So, that is used there in its generic sense. Now, how about RTC to CA? If it is the decision of the RTC in its original jurisdiction, notice of appeal. Where will you file the notice of appeal? RTC. Not to the CA, but RTC, the Court of Origin. If the decision sought for appeal is decided by the RTC in its appellate jurisdiction because it was originally decided by the first level, PETREV, Petition for Review, under Rule 42. CA to SC, PETREV on certiorari under Rule 45, also known as appeal by certiorari, if question of law is involved. If not, because the question is both of law or fact, notice of appeal. Okay? Notice of appeal. So what do we mean by questions of law or questions of fact? Question of law exists when the doubt or difference arises as to what law is on certain state of facts. In other words, we are actually questioning the applicable law. We are questioning the law used or applied by the court in arriving at a decision. It's on its interpretation of the applicable law from a particular fact. So we are questioning that should not be the law that should be applied, but it should be this way. Okay, so the doubt or difference arises to what the law is on certain state of facts. Unlike question of fact, it exists when the doubt or difference arises as to the truth or the falsehood of alleged facts. It's on the appreciation by the court of the facts as alleged by the parties or the litigants. Okay, so that distinguishes question of law from question of fact. Service. Remember that we have to furnish a copy to the opposing party. How do we do it? In Section 4, it provides, if personal service of the copy of the notice of appeal cannot be made upon the adverse party or his counsel, service may be done by registered mail or by substituted service pursuant to Section 7 and 8 of the rule. Meaning to say, while you have their service may be done by registered mail or substituted service, it did not actually deter or prevent a party from furnishing the opposing party or the adverse party of a copy thereof personally. You can deliver it personally. If it is practical, then you may do so. If not, then through registered mail or by substituted service. So the substituted service could either be on private couriers. In Section 5, you have there the appealee may waive his right to a notice that an appeal has been taken. Who is the appealee again? He is the adverse party because the person or the party who initiates the appeal is called the appellant. The appellee may waive his right to a notice that an appeal has been taken. Okay, so the discretion, the appellee is actually given that discretion to just waive a copy. The appellate court may, in its discretion, entertain an appeal, notwithstanding failure to give such notice if the interest of justice so require. When appeal to be taken, an appeal must be taken within 15 days from promulgation of the judgment or from notice of final order appealed from. This period for perfecting an appeal shall be suspended from the time a motion for new trial or reconsideration is filed until notice of the order overruling the motion has been served upon the accused or his counsel, at which time the balance of the period begins to run. Now take note that the provision under Rule 122 still talks about balance of the period begins to run. What does this mean? That if you are given a period of 15 days within which to appeal, let us say that the decision was promulgated today. So if you are given 15 days, meaning to say, you have until December 16 within which to file within, not after the lapse, but within the period of 15 days from today within which to file an appeal. Now, on the 10th day, meaning to say, let's say that on December 9, you file a motion for new trial or reconsideration. Let us say that the court resolved it right away on December 12. So how much more is left to you? You have 4 days from December 16 because the old rule says balance of the period begins to run. But as we discussed before, in the case of you versus Samson Tatad, adopting the NAPIS rule, you are actually given a fresh period of 15 days within which to appeal. In other words, if the motion for new trial or reconsideration was filed on the 9th of December, meaning to say December 9, and it was resolved by the court, let's say December 12, para we have a uniform date. So, the 15-day period, since you will be given a fresh period of 15 days, it shall reckon to run from December 12 and not from December 1. Because that December 12 there is your notice or receipt of the order, final order appealed from. Because the law uses promulgation of the judgment or from notice of the final order appealed from. So, your reckoning point is not on the date of the judgment, but the date to which you receive the order denying your motion for new trial or motion for reconsideration, hence you are now filing an appeal. Okay, so fresh period of 15 days. So what happened in that case of you versus Samson Tatad? So the court ruled that the provision provides that the period for appeal in all cases shall be 15 days counted from the notice of the final order, resolution, award, judgment, or decision appealed from. The law, according to the court, makes no distinction between the periods to appeal in a civil and a criminal case. Hence, added the court, when the law makes no distinction, the court also ought not to recognize any distinction. Hence, following the NAPIS rule, you also have there the case of you versus Tatad, giving the aggrieved party a fresh period of 15 days within which to appeal. Transcribing and filing notes of stenographic reporter upon appeal. So in a court setting, so aside from the judge, you have there the court interpreter, you have there the clerk of court, you have there the so-called stenographer. The stenographer is the one who records everything. And he transcribed such transcription. We call it the transcript of stenographic notes or the TSN. When notice of appeal is filed by the accused, the trial court shall direct the stenographic reporter, the stenographer, to transcribe his notes of the proceedings. When filed by the people of the Philippines, the trial court shall direct the stenographic reporter to transcribe such portion of his notes of the proceeding as the court, upon motion, shall specify in writing. The stenographic reporter shall certify to the correctness of the notes and the transcript thereof, which shall consist of the original and 4 copies, and shall file said original and 4 copies with the clerk without unnecessary delay. So how much copies where the stenographer prepares? 1 original plus 4 copies. If death penalty is imposed, the stenographic reporter shall, within 30 days from promulgation of the sentence, file with the clerk the original and 4 copies of the duly certified transcript of his notes of the proceedings. No extension of time for filing of said transcript of stenographic notes shall be granted except by the Supreme Court and only upon justifiable grounds. Transmission of papers to appellate court upon appeal. So, what would happen? Remember that the notice of appeal is filed in the court of origin. So what shall the court of origin do when it receives the notice of appeal? Within 5 days from the filing of the notice of appeal, the clerk of court with whom the notice of appeal was filed must transmit to the clerk of court of the appellate court the complete record of the case together with said notice. In other words, the clerk of court of the RTC shall transmit, or in layman's terms shall forward, but the accurate word is transmission, transmit. Transmit it to the clerk of court of the appellate court, or let's say the CA, the complete record of the case together with said notice. The original and 3 copies of the transcript of stenographic notes together with the record shall also be transmitted to the clerk of the appellate court without undue delay. The other copy of the transcript shall remain in the lower court. Remember that the stenographer is required to prepare 1 original, 4 copies. But when the same shall be transmitted, what shall be transmitted is the original plus the 3 copies. Remaining 1 copy with the lower court or the court of origin. Appeal to the RTC. Within 5 days from perfection of the appeal, the clerk of court shall transmit the original record to the appropriate RTC. So, whom are we referring to this? The MTC, the first level. So, within 5 days from perfection of the appeal, the clerk of court shall transmit the original record to the appropriate RTC. Upon receipt of the complete record of the case, transcripts, and exhibits, the clerk of court of the RTC shall notify the parties of such fact. Within 15 days from receipt of said notice, the parties may, take note ha, may submit memoranda or briefs. We call this as the appeal brief. So, if you are the appellant, you will file an appellant's brief. If you are an appellee, so appellee's brief. Or may be required by the RTC to do so. After the submission of such memoranda or briefs, or upon the expiration of the period to file the same, the RTC shall decide the case on the basis of the entire record of the case and of such memoranda or briefs as may have been filed. So if you notice, the entire record shall be transmitted from the first level to the RTC. Will the RTC conducts trial again? No. He will just review the entire record. How about the memoranda or briefs, if any? Now, if one is filed, it will also be considered. But if none was filed, it is also not fatal. In fact, the non-filing of memoranda or briefs is not a ground for the dismissal of the appeal because the rule says may submit. Hence, the RTC shall not receive new evidence or conduct a trial before deciding on the appealed case, because the decision of the RTC is based on the entire records of the case and the memoranda or briefs filed by the parties. However, that is the RTC. However, the CA shall have the power to try cases and conduct hearings, receive evidence, and perform all acts necessary to resolve factual issues raised in a continuous basis, and has to be completed within 3 months unless extended. Remember that in the CA, you can raise issues of facts and law. Hence, if it involves facts, then the CA may conduct hearing. Unlike in the RTC, wherein the review is based solely on the records transmitted from the first level courts. Transmission of records in case of death penalty. In all cases where the death penalty is imposed by the trial court, the record shall be forwarded to the Supreme Court for automatic review and judgment within 5 days after the 15th day following the promulgation of judgment or notice of denial of a motion for new trial or reconsideration. Again, impliedly repealed because we have to observe the hierarchy of courts. It has to be forwarded first to the CA prior to the SC. The transcript shall also be forwarded within 10 days after the filing thereof by the stenographic reporter. Now, what would happen if there are more than one accused in a case and only one filed an appeal? An appeal taken by one or more of several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. For those who were under me when we discussed probation, with the amendment of probation, that the accused may file an appeal on the provision that he questions solely on the imposition of a non-probationable penalty. Okay, remember, non-probationable penalty. And on appeal, it was granted, meaning to say the higher court, the appellate court, imposes upon him a lower penalty, which is a probationable one. From receipt thereof, he has within 15 days within which to file his application for probation based on the modified decision. Now, how about those co-accused who did not appeal? Can they also file probation based on the modified decision? So when we had a lecture on probation, I told you that they cannot file probation because their decision, their judgment of conviction has long been final. However, you have there, insofar as the judgment of the appellate court is favorable and applicable to the latter, the least that they can avail of is to manifest to the court that they want to avail sorry they want to avail of the modified decision, not for applying probation, but for purposes of the service of their sentence, but based on the modified decision. So, in effect, if the penalty they are serving is 6 years and on appeal it was lower to 4 years, then those accused who did not file an appeal may avail of the 4-year term as decided by the appellate court. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or ordered appealed from. Okay, so the offended party, since appeal can be done by any party, the offended party may actually file an appeal on the civil aspect of the case. And any decision of the civil aspect shall not affect the criminal aspect of the judgment or order appealed from, especially if the accused was acquitted. So the acquittal there is on the criminal aspect of the case. So it will not actually deter or prevent the offended party from filing an appeal of the civil aspect of the case. Upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as to the appealing party. In other words, as far as the appellant is concerned, his conviction is not yet final pending resolution of the appeal. Okay, pending resolution of the appeal. Or, if we talk about the civil aspect only, then that civil aspect shall not set in unless there is that resolution of the appeal. So, in the meantime, the order of the trial court of the civil aspect is stayed. Meaning to say, stayed or suspended or have to wait for the resolution by the appellate court. Exception. Insofar as the judgment of the appellate court is favorable and applicable to the latter. What does this mean? Remember that on appeal, it would actually throw the case wide open. In fact, the CA can even review issues or questions not assigned on appeal. Okay, the errors there, di ba? You have to assign them as error. The CA is not actually prevented from resolving issues, even if the same was not raised on appeal. It throws the case wide open. So it would be possible that at the end of the day, the appellate court may either affirm the decision rendered by the trial court, or it may even modify the decision rendered by the trial court by reducing the penalty imposed. It may also increase the penalty imposed. Would it violate the right of the accused to double jeopardy? No, remember? It was at his initiative that his conviction, he appealed his conviction. He waives his right against double jeopardy. He throws the case wide open. So what would happen? On the modification of judgment, as to the lesser, the decrease of the penalty, the other co-accused who did not appeal may avail. Because it says here, insofar as the judgment of the appellate court is favorable and applicable to the latter. But as far as increasing the penalty, that shall only be applicable to the accused who appealed. It will not affect the penalty imposed by the other accused who did not appeal. You will not apply that to them because that would not be favorable to them. That is the risk that the accused who filed an appeal has to take. Okay? So sometimes being practical also would be helpful. So if not beneficial, the decision of the appellate court shall not affect those who did not appeal. What is the so-called harmless error rule? Now, while the case is thrown wide open on appeal, it is likewise a principle in law that not all errors committed by the trial court are grounds for reversal of the appeal judgment. The court may not even modify. If the error is slight and insignificant, the error will be disregarded because it has not caused prejudice to a party. That is what we call as harmless error rule. Can an appeal be withdrawn? So you have there section 12 that governs the same. Notwithstanding perfection of the appeal, Now, you might be asking, so when is appeal perfected? Remember that you filed a notice of appeal within a period of 15 days. So prior to the 15-day period, you file a notice. So when is it perfected? After the lapse of the 15-day period. The RTC, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court, as the case may be, may allow the appellant to withdraw his appeal before the record has been forwarded by the clerk of court to the proper appellate court as provided in Section 8, in which case the judgment shall become final. So in other words, prior to transmission by the clerk of court of the trial court to the clerk of court of the appellate court, you may withdraw the appeal. Effect, the judgment which you supposedly wanted to appeal shall become final with your withdrawal of the appeal. The regional trial court may also, in its discretion, allow the appellant from the judgment of a metropolitan trial court, municipal trial court in cities, municipal trial court, or municipal circuit trial court to withdraw his appeal, provided a motion to that effect is filed before rendition of the judgment in the case on appeal, in which case the judgment of the court of origin shall become final and the case shall be remanded to the latter court for execution of the judgment. Now, this paragraph says or would tell us that there is already transmission of the records. So from the first level to the RTC, there is that transmission already. But the appellant still has that discretion to withdraw the appeal. What he shall do is to file a motion to that effect. Okay, file the motion. Where will you file the motion? With the RTC. Because the decision of the first level is now pending for review with the RTC. So you want to withdraw? That can be done before rendition of the judgment by filing of a motion. In effect, or the consequence is that the decision of the first level shall become final because you withdraw the appeal. So the RTC shall refer back the case to the first level or to the court of origin for execution of the judgment because it's already final with the withdrawal of your appeal. Appointment of counsel de officio for accused on appeal. Now, this is especially true especially if the appellant did the appeal himself. So it shall be the duty of the clerk of court of the trial court upon filing of a notice of appeal to ascertain from the appellant if confined in prison, whether he desires the regional trial court, the court of appeals, or the Supreme Court to appoint a counsel de officio to defend him and to transmit with the record on a form to be prepared by the clerk of court of the appellate court a certificate of compliance with this duty and of the response of the appellant to his inquiry. Okay, so the clerk of court shall prepare a certification to that effect. So those are the salient features, but a sort of reminder. So I have these notes with respect to the rule on appeal. Remember that appeal is not a natural right, nor it is a component of due process. You have to remember that it is merely statutory privilege. But once granted, its suppression would be a violation of due process. If accused filed an appeal of his conviction, it constitutes a waiver of his constitutional right against double jeopardy. Because on appeal, the case throws the entire case for review, even on errors not assigned, but for issues not raised by the parties in their pleading, such as fury, not allowed. Okay? That is, though the CA may review even on errors not assigned, but not on fury. but it purely must be based on in law and facts. Factual findings of the trial court, especially when affirmed by the CA, deserves great weight and respect. Filing of memoranda may or may not be required. Meaning to say, non-filing of the memoranda should not be a ground for the dismissal of your appeal because it is merely discretionary. Appeal by any of the several accused is allowed, but if favorable decision is obtained, the other accused who did not appeal may benefit from the favorable decision of the appellate court. It goes to say that if the decision of the appellate court would not be favorable to the accused, let's say the penalty was increased, it will not affect those accused who did not appeal. If SC en banc is equally divided, especially if the judgment of equally divided, or let's say if death penalty, the vote of 8 was not obtained, so death penalty will not be imposed. But here, if it is equally divided for a penalty that death penalty was not imposed, that would mean that the judgment of the lower court shall be reversed and the accused in effect is acquitted. Okay, so those are some of my reminders on appeals. With that, thank you, and always remember that it pays to read. Okay, there is no substitute in reading, so keep on reading and please do understand what you are reading. Good evening.